Welcome back to the deep dive. Today, we're stepping into, well, kind of a time machine.
We are.
We're going back to a period of absolute chaos, the English Civil War in the 1640s. And I want you to just imagine a scenario.
Okay.
You're a tenant farmer, you've signed a lease to rent some land, you're minding your own business, trying to grow your crops, and then suddenly an invading army shows up.
And not just any army.
No, this isn't just a rowdy group of locals. We are talking about a foreign prince with a hostile force. They kick you off your land, they occupy it for 3 years, and you cannot make a single dime or, I suppose, a single shilling of profit.
It sounds like an absolute nightmare scenario, but legally, it's a fascinating laboratory for testing the limits of obligation.
It is.
Yeah.
But here's the kicker, and this is the central problem we are tackling today. When the landlord comes around collecting rent for those 3 years where you couldn't even step foot on the property,
Right.
do you have to pay him?
It's a question that seems to have a really obvious moral answer. Of course not.
Right, I couldn't use the land.
But it has a very, very different legal one.
Exactly. So to unpack this, we have a very specific mission today. We're looking at the origins of contractual liability through the lens of this specific historical disaster.
Right. And to do that, we're going to follow a specific analytical path. First, we have to examine the landmark case of Paradine v. Jane from 1647.
The case that starts it all.
It really does. Second, and this is crucial for understanding the logic here, we have to define the distinction between duties created by the law versus duties created by a contract.
That distinction is the hinge the whole door swings on.
It is. And finally, we will apply the doctrine of absolute liability. We're going to see just how absolute that word absolute really is.
Okay, so let's set the context. It's 1647. We're in the King's Bench. The English Civil War is raging.
And our mission really is to understand why the court decided that inevitable necessity, basically a disaster you cannot stop, was just completely rejected as the defense for breaching a contract.
Let's dive into that core concept first, because I think most people would assume that if a disaster happens that isn't your fault, you shouldn't be on the hook. So does the law treat all duties the same when disaster strikes?
No, it absolutely does not. And this is where we have to state the general rule. There's a fundamental, a structural difference between a duty that is imposed on you by the law and a duty you voluntarily assume by entering a contract.
Okay, let's break that down. What happens if the duty is imposed by law?
So let's call this element A of the rule. If the law creates a charge or a duty and a party is disabled from performing that duty without any fault of their own, and this is important, they have no other remedy, the law will excuse them.
So if the law says don't do this, but a hurricane, say, forces my hand, I'm off the hook.
Precisely. The source material gives the example of waste. There's a legal duty not to commit waste. Essentially not to let a property be destroyed. But if a house is destroyed by a tempest or by enemies, the law excuses the lessee because you didn't choose that duty. The law put it on you, so the law gives you an out when things become impossible.
Okay, that feels fair. But what about element B? What about duties we sign up for ourselves?
And this is where the trap snaps shut. If a party creates a duty upon themselves by their own contract, they are bound to make it good, notwithstanding any accident by inevitable necessity.
Bound to make it good. That sounds incredibly strict. Why? What's the rationale behind holding someone liable for the inevitable?
The court's reasoning is, well, it's grimly logical. They say the party is liable because he might have provided against it by his contract.
Ah. So because you didn't write a what if an army invades clause, the court assumes you meant to pay no matter what.
Exactly. The silence of the contract is interpreted as the assumption of risk. If you didn't explicitly exclude the risk of a foreign invasion, you own that risk. The law just won't protect you beyond your own agreement.
That is a harsh lesson in contract drafting. You have to predict the unpredictable.
Or be prepared to pay for it.
Okay, we have the theory. Now let's see this play out. Let's analyze Paradine v. Jane. First, what are the legally dispositive facts?
Okay, so the essential facts are these. The plaintiff, Paradine, leased some land to the defendant, Jane. It was a lease for years, and it required Jane to pay rent at the 4 usual feasts, basically quarterly payments.
Standard setup. Then what happened?
Disaster. Jane pleaded that Prince Rupert, a German prince, an alien-born, and an enemy of the king, invaded the realm with a hostile army.
And this army?
This army entered the defendant's possession and expelled him.
They kicked him out.
Completely. And they held possession of that land for 3 years. So as a result, Jane couldn't take any profits from the land during that entire occupation. Paradine, the landlord, then sued Jane for all the unpaid rent for those 3 years.
That's just adding insult to injury. You lose your farm to a German prince, and then your landlord sues you. Okay, and what was the core legal issue?
The precise legal issue is whether a lessee is excused from his covenant to pay rent when an alien enemy army occupies the land, making performance and any profit-taking impossible due to that inevitable necessity.
And what rule of law did the court apply? Can you state the full black-letter rule and break it down into its testable elements for us?
Of course, the court applied the rule of absolute contractual liability, and we can break this rule down into 3 distinct elements.
Okay.
Element 1 is the existence of a covenant, that is, a contractual duty to pay rent. Element 2 is the absence of an explicit exception clause in the contract, the failure to provide against it.
Got it.
And element 3 is the application of what the court called the casual profit versus casual loss risk allocation.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the nature of the covenant?
So here, the court did a little mini IRAC. The sub-issue was whether the duty to pay rent was a legal duty or a contractual one. The court determined the rent is a duty created by the parties upon the reservation.
Meaning it was part of their deal.
Exactly. Because it's a covenant in law, which they treated as the same as an actual written covenant, the duty is self-imposed. It's not like the duty to avoid waste, which the law imposes. So the first element was met. This was a voluntary obligation.
Understood. It all comes back to that first distinction we made. Now, what about the second element, the allocation of risk?
For this element, the court looked for an excuse, inside the document itself. The reasoning was because the lessee might have provided against it by his contract, meaning Jane could have put in a clause saying, I don't pay if Prince Rupert invades.
But he didn't.
He didn't. And because he failed to do so, the law would not protect him beyond his own agreement. The court applied the fact of the contract's silence to conclude that Jane implicitly accepted the risk of interruption by enemies.
It's the sound of silence working against the defendant. And the third element, that economic balance of casual profits and losses.
This is really the court's equity argument. They reasoned that a lessee gets the advantage of casual profits, unexpected good years, bumper crops, high prices.
The upside.
He gets the upside, so he must also run the hazard of casual losses. The court argued it would be unfair to put the whole burden on the lesser, Paradine, who would lose his rent while the lessee just loses possession. So that economic balance element, it weighed in favor of enforcing the contract.
And after analyzing all the elements, what was the court's final conclusion?
The plea was resolved insufficient. Judgment was given for the plaintiff, Paradine. Jane must pay the rent despite the German prince's invasion.
That is just a rough outcome for Jane. Now, the source material also notes some procedural nuances. I don't want to gloss over those just for completeness.
Yes, and these are important, I think, for understanding how incredibly picky these courts could be. The plea was also, arguably insufficient on technical grounds.
How so?
Because Jane didn't answer for 1/4's rent. The occupation didn't cover the entire period he refused to pay for perfectly.
So he held back a bit too much.
Right, and secondly, he didn't prove that the entire army were aliens.
What difference would that make?
Well, the court implies that if some of them were locals, Jane technically had a remedy over, meaning he could have sued the non-alien soldiers for damages.
Which sounds practical in theory, but imagining a tenant farmer suing a marauding army during a civil war seems
optimistic.
Wildly optimistic.
Highly. But legally, the existence of that, that theoretical remedy meant he wasn't completely without options, which just further weakened his claim for an excuse.
I really want to drive home how severe this rule is, because Prince Rupert invading feels like this very specific historical thing. But the principle is so broad. Can you give us some other examples to illustrate just how harsh this absolute liability really is?
I can. The source material provides some incredibly visceral imagery to really cement this concept. These are hypotheticals that show the court was laying down a hard line.
Okay, give us the first one.
Let's consider the wildfire hypothetical. The court cites authorities stating that even if the leased land is made barren by wildfire, the tenant must still pay the full rent.
So the land is burnt to a crisp, you can't grow a thing, but the rent check is still due.
Correct. It's treated as a casual loss that you, the tenant, have to bear.
Wow. Okay, what about something even more extreme? What if the land isn't just burnt, but it's gone?
This is the C hypothetical, and it is, I think, the most shocking one. The court notes that even if the land is surrounded or gained by the sea,
Meaning it's underwater.
the ocean has literally swallowed your farm. It's gone. Even then, the lessor is entitled to his whole rent.
That is mind-blowing. You were paying rent for a patch of ocean.
Because, again, you could have written a clause that said, I stop paying if the land turns into the Atlantic Ocean. You didn't, so you pay.
Unbelievable. And there was one more about a house, right?
Yes, the lightning hypothetical. If a lessee covenants to repair a house and it is burnt by lightning, they are not excused. They must rebuild it.
Lightning. I mean, we usually call that an act of God.
To the court in 1647, lightning and invading armies are simply treated as accidents that you should have planned for. They are risks that fall on the party who made the promise.
It really reframes how we think about contracts. It's not just an agreement to do something.
No.
It's an agreement to accept the risk that doing it might become impossible.
Precisely. It turns the contract into an insurance policy where the promiser is the insurer.
Okay, we've dissected the case. We've looked at the terrifying hypotheticals. Now, let's make this usable. If someone is looking at a fact pattern, how do they navigate this kind of problem?
We can synthesize all these rules into a diagnostic checklist, a sort of exam framework. There are 4 steps you need to walk through to figure out liability in these situations.
Walk us through step 1.
Step 1 is to identify the source of the duty. You have to ask, was this duty created by law or was it created by contract?
Look.
If it's created by law, like the duty not to commit waste, then impossibility or an act of God is a valid excuse. You can stop there. The party is excused.
But if it is created by contract, like our friend Jane,
Then you go to step 2. Check the contract text. Did the party provide against the event? Did they write in a force majeure clause, a war exception, anything like that? If they did, great, you just follow the contract clause.
and if the contract is silent,
Then you move to step 3. Apply absolute liability. The party is bound to make it good, notwithstanding inevitable necessity or accident. That silence is fatal to their defense.
is there a final check?
There is. Step 4. Check for a remedy over. Does the party have a remedy against the disruptor? Just like the court suggested, Jane could theoretically sue the army.
Right.
If there is a third party they can sue, this just strengthens the argument against excusing their performance because the law expects you to pay your landlord and then go chase the bad guys for your money yourself.
That is a rigorous framework. It leaves no wiggle room at all.
It wasn't designed to be flexible. It was designed to be certain.
So let's wrap this up. We've taken a deep dive into 1647. We've seen a tenant farmer lose everything to a prince and still owe rent. What's the big takeaway here?
The big takeaway is that Paradine v. Jane establishes that in the eyes of the common law, a contract was an ironclad bond. It wasn't a casual promise, it was a strict allocation of risk. And not even a prince's army could break that bond.
So if you didn't write an exit strategy into the text,
The law was not going to give you one. It really emphasizes the power of the written word.
and the danger of what's left unwritten. Before we go, do you have a final thought for us to chew on?
I do. The court mentioned that if a land is gained by the sea, you still pay. And it raises this fascinating philosophical and legal question. At what point does the subject matter of the contract cease to exist entirely? If I rent a farm and it becomes the sea, I still pay. But what if the entire country disappears? At what point does reality finally overgird the contract? It suggests that in 1647, the contract was more real than the land itself.
The contract is more real than the land. That is a haunting thought to end on. Thank you for listening to this deep dive. Check your leases, everyone. We'll see you next time.